Ain't no half step on Marcus J. Live from the den. Legacy Internet Radio. Thank you to everybody who allowed us to take that brief break to reset and recalibrate the show. At this time, we are going to move into our segment of the night. We are going to call Legal Eagles. At least we're going to call it that for now, because I'm getting the faces right now. They're like, what is that? That's corny. But I was told on the air recently that I'm corny, so I guess that's okay. But anyway, I am happy and honored to have our sister attorney Tamika Robinson with us, and we're going to go over a couple of things here in the Legal Eagle. So what are the actual topics, and that we're going to go over all of them, and then we'll break down each one and talk about them.
All right. So tonight we're going to talk about wills, power of attorneys, and advanced health care directives, otherwise known as living wills. Together, these are normally determined to be your estate planning documents.
Okay. So let's jump right into it. Which one are we going to get into first?
We can talk about wills first.
Okay.
So just to throw out a couple of numbers at you so that you understand where most Americans fall. I did a little bit of research. So in 2016, it turns out that 55% of the population does not have a will.
Wow.
And 66%, or 2/3 of the population, does not have an advanced health care directive or a living will. In 2017, it looks like they surveyed about 1,000 people. Of those 1,000 people, they broke it down into age brackets. So 78% of who were surveyed, millennials, 18 to 36, had no will. 64% Gen X, ages 37 to 52, had no will, and about 40% of the age bracket between 53 to 71 has no will. So, generally speaking, now moving forward to 2016, on the flip side of that, that means that only about 42% of the population have estate planning documents. Dealing with most people that have children under the age of 18, only 36% of the population has some kind of will or document.
36%.
36%. So what that means is that most Americans are not planning for the inevitable. We all know that one day we're all going to die.
Not me.
We're all going to die.
I ain't going no place.
Forever.
And then when I do like what y'all call die, I'm gonna have like the people that I really, really love, and y'all know who y'all are, and then the people that I really don't like, y'all know who y'all are. I'm gonna haunt the hell out them. You know what I'm saying? Like I'm gonna be moving curtains, blowing winds, smacking drinks over,
So I need to burn some sage.
tickle
Keep you out.
ears, and feed. Yeah, okay. All right. You do realize that's how this segment's going to go, right?
I know.
Okay.
And I know we're trying to lighten it up because most people really don't want to think about planning for the inevitable,
Yes.
but it needs to happen. The last thing you want to do is pass and not have stuff in order and leave it up to your family and your loved ones to deal with not only your death, but also what to do with all of your stuff.
Yeah. Well, I could tell you from my experience in this, I haven't done it. I need to do it, and I'm sure, once you start kind of talking to me about, or us rather, about this, I'll be encouraged to make sure that I do it. But I remember when my parents sat me down. It's been more than 5, less than 10 years, and they're in their 70s now. And I was home in Jersey visiting, and they said, all right, this is where this paper is, and this is where that paper is, and this is where you find this and that.
Right.
And I'm looking at them like, hold up, what are we doing here? I don't want pomegranates. I don't want to talk about this. And it's like, I know you don't want to talk about it, but we need to talk about it. So
they love you, so they're telling you
Right.
to ease your mind when the time comes.
Right.
yeah.
And, and that was the same with me. Like we talked earlier, after my grandmother, the confusion we had. So definitely I had that conversation. My mom called me and my brother over, and we didn't want to have that type of conversation, but it was a needed conversation, which actually got me to thinking like, okay, I got two of my own. I need to go ahead and start writing mine. So, but I went a little bit further than the will. I planned the whole funeral.
Yeah.
So,
Well,
yeah.
I have done that.
Yeah.
I've done that. I won't say on air what I've done, but if you know me, I ain't going in the ground. I just leave it at that.
Right.
I ain't going in the ground. But I'm gonna have you go back to one of those stats for a second to me, because I got a question. You said overall, what is that number for people who have children under the age of 18? What is that percentage of?
36%.
Thir-
That is the most important. That is the most important segment of the population that needs to have estate planning documents.
Why is that?
What are you going to do with your children when you die?
Okay.
You don't want a stranger or the court having to come in and make a decision as to who gets your children.
So let's say, for example, if my child and her mother, if I and my child's mother both become deceased at the same time, she's 14, and we've not made any provisions. She's got 2 full sets of grandparents. She's got she's got 2 aunts and she's got 2 aunts and an uncle who have children of their own. And I guess my point is she's got plenty of people who could step in and take care of her. But that's not my question. My question is, legally, what can happen if we don't do this the right way?
There's going to be a custody battle.
Okay. And how does that work? Like, is it, let's say my mama wants her and her other grandmother wants her, and they get to fighting.
The court's going to determine what's going to be in the best interest of the child.
Okay.
Specifically with your child, because of her age,
14.
they're going to take into account if she has her own choices and her opinions on where she wants to go.
Okay.
They will definitely take that into account, and the older the child is, the more heavily they will consider what the child wants. But ultimately, the court is going to have to funnel through everything, funnel through everybody, and make the decision according to what they feel the best interest of the child is as to where they're going to go.
So I'm not speaking autobiographical, but I'm speaking more generally, but I'm using myself as the example. If there's a family member that I personally don't care for and I'm gone and I never made that plain, it's possible my child could end up with that person if I don't make it plain.
Correct.
Okay.
And that process take like a year or so. That whole process.
It depends on how much back and forth there really is. It could be quick, or it could be drawn out, and overall it's going to be to the detriment of the child.
Right.
Nobody wants to be fought over like a piece of property,
Right.
which is essentially what happens.
Right.
So now you have a child that has to deal with not only the trauma of losing both their parents, because of course this is something that happens in a situation where both parents are deceased. Not only does that child have to deal with losing both of their parents, but they have to deal with the trauma of being in court and being subject to all of that mess. And so that is just something that's not fair to put on a child due to your lack of planning.
Right. Now, for the purposes of our discussion tonight with regards to wills, is it mostly about family planning, or is there another piece to this that you were looking, when I say family planning, I'm like, what happens to your kid? Is there another piece to this that you want to kind of get into? For example, I'm not rich. I don't know anybody in my demographic that is, but I do have a little bit of coin that I don't want to end up in the wrong place. So, is there provisions for that in the will versus, let's say, for example, I had enough money and I don't. I'm gonna die broke. Trust me. If I died tomorrow, I would anyway. But let's just say I got $500,000 in the bank,
Okay.
and that $500,000 is plenty enough to pay off all my bills. We're speaking hypothetical. What happens to my money if I don't have a will?
Your money that's in the bank?
Yes. Let's say I got $500,000 in the bank, and I'm reaching high, y'all.
Speak
Speaking
into existence.
I got $500,000 in the bank, and $100,000 worth of debt. So that's $400,000. $500,000. That's terrible with math. Yeah, just $400,000. Yeah. Okay. I got that money that's left. I'm terrible with math. You're making faces at me. You get the point I'm trying to make. I'm trying to say I paid off my bills from the other side, and there's money left over, y'all. That's what I'm trying to do. I'm terrible with math. But before you answer that, let me get a comment in. Our sister Megan of the Satin Room here on Legacy Internet Radio says that she hadn't thought of any of this, and she's got 2 children. So great info. Wow. Great info. So we're getting some love from the folks checking us out. So anyway, terrible with math, but my point is I got money that pays off my bills. There's money left over. I do not have a will. What happens to my money?
So let's backtrack.
Okay.
The money that's in the bank is not going to pay your estate.
Oh.
Because that money is not considered part of your estate. So without trying to get too technical, you have your property that you own breaks down into 2 specific segments. You have probate property, which is subject to being passed through a will, and you have non-probate property. A bank account is considered one of those items. That is left to whomever by way of a beneficiary. So when you go into the bank and you open up an account, they'll say, do you want to put a beneficiary on your account? Yes, and then you write down who that person is.
Okay.
If it's a joint account, then you're starting to get into technicalities, but usually it goes to the other person that's on the joint account with you.
Okay.
So that wouldn't be touched by a will. So whoever inherits that money,
That's their money.
that's their money. They can do with what they want.
Okay.
One of the misnomers that people have is that they think that they shouldn't make a will because they don't have a lot. I don't have money. I don't have a business, I don't have this. But if you have property, a car, a house, clothes, shoes,
Studio equipment.
all of that, all
Yeah.
of this. And if you have a business, all of those things are considered your property, and somebody has to figure out what to do with it when you die.
Right.
And so this is your stuff. And I just always tell people when they talk to me about making a will, I don't want to make this decision. But this is your decision to make because these are your things. And it's not fair to put that on somebody else. You need to take the time and decide what to do with your things.
Yeah. Ain't no half step on Marcus J. Live from the Den, Legacy Internet Radio. We're talking to our sister attorney Tamika Robinson. She is our legal eagle. And we are debuting a segment here on the show where we're going to be talking about legal issues monthly. So very happy and excited to bring this to you. You got a question?
Yeah. So what happens like when you write out a will, and I've seen watching movies and stuff, and you've seen that like a person comes in, and now the will is changed in favor of them. How does that come into play? Because a lot of people start questioning, like especially if it's a new wife or something like that, and then the kids be like, "Oh, he was old. He or she kind of talked them into it." How does that work?
So generally speaking, what you're talking about is a term that's people call undue influence, right? You have somebody who is close to the person that made the will, and other people feel that they've been influenced in some way, and that they didn't maybe have the capacity to understand the changes that they were making, or they were manipulated, etc. So if you have a situation like that, usually what happens is The will is submitted to the court to probate in order for the court to appropriately hand out the property as the will says. And the party that feels wronged or that wants to challenge it would do what's called contesting the will.
Okay.
So they would just tell the judge, and submit their arguments as to why it shouldn't be done this way and go on from there.
Okay. Wow.
Did you have a question?
Yeah, so I have a car payment. So when it comes to, as you mentioned, property, in my will, would I be able to say what person I want to pay that payment, or would it just be, it's in your hands now, you do what you want to do with it?
So typically what happens is you can pass your car on to another person and debt follows the property. So if it's a house and there's a mortgage, the debt's going to follow. If it's a car, the debt's going to follow. You can make a provision in your will that says any money that you have or you want the executor of the will, which is going to be the person that's in charge of doing everything and handling your estate, you can direct them to pay the debts first, and then whatever is left over, divvy it out accordingly.
Okay.
Wow.
Wow. Now, I got a question about debt. Once you go, your debt doesn't go.
No.
And I've always been, I don't even, honestly, I was going to say I've always been confused about it. I don't even know how to really ask the question. But, if I die and I got a bunch of debt, is it really okay for those debtors to come from my family?
They don't
When
come
I'm
for
the
your
one-
family, they come for your estate.
Right, the estate. But if I owe you money, trust me, I ain't got no money. That's the whole point. You know what I mean? That's the whole point. And so, obviously, some folks have life insurance and things of that sort. So that's what you mean by the estate. But let's assume, for the purposes of this question, that when I go, I'm leaving debt, not leaving no money. So what happens then?
It depends on the creditor, AKA who you owe.
So some of them could just be assholes about it and come for your family.
They could, and some could waive it. Sometimes when you take out certain debt, there is an extra
Because I can assure
option.
you, if somebody that's close to me dies with debt, especially debt that doesn't have my name on it,
Right.
No,
It's true.
hell no.
It's true, but
I guess
there
legally,
you
how
have
do I deal with
provisions.
that, Lee? I'm clowning, but legally, how do I deal with that?
So it depends on how the debt was obtained in the first place. When you first take out a loan or a car loan or something along the lines, sometimes the lender has a provision that will allow you to take out extra insurance, which in the event you die will cancel that debt.
Okay.
So if you have that option, or that's always an option that you should ask about, if they get that option, that's always a good option to take. Outside of that, once your death certificate is processed, it is in vital statistics. So it puts the world on notice about your death.
Okay.
So does a will. When you register wills or you register the probate or whatever, it puts everybody on notice that you have died. And so creditors at that point have the opportunity to come and try to get paid out of your estate.
Okay.
Now, without getting into too much specifics, because like I said, every state is a little bit different. There are, depending on what is a part of the estate, there are some things that just can't be touched.
Okay.
So there's some, family heirlooms, for example, like the family Bible, things like that. Those types of things, they can never try to come after and get that in order to pay their debt.
So they can't get the ring that great granddaddy gave to great her.
In most situations, yes. In most instances, yes, that is correct.
Okay. And you know how to start with Marcus J. Live from the Den, Legacy Internet Radio. You got a couple other things, and we still have wills on the table. So if we get questions in social media on wills or anything else, by all means, or even in the room, It's on the table, but you got one more or two more topics in there. You got two more, okay.
Two more.
So give us the next one. Let's start talking about that. Like I said, the others are the first one is still on the table.
So the next one can kind of go hand in hand with the last topic, but the next one you're talking about are power of attorneys.
Okay.
So power of attorney is something that you use while you are alive. One mistake that people make is that when somebody dies, they come and say, I have the power of attorney. It doesn't work after somebody dies.
It doesn't.
It does not.
Wow. Okay.
It's
Didn't know
done.
that.
I did not know that.
Yes.
Yeah.
Power of attorney is only good for when the person is alive.
Wow. Okay. Well, the inevitable question is, first of all, why not? Is there a legal precedent that you're aware of, one? And two, what takes over then?
The will,
But if you don't have one,
the state.
so the state, see, okay, so now it's becoming, I mean, obviously we knew that we needed to get a will. We knew that. But what you don't want is the state that you already pissed about because you got to pay them taxes.
Right.
And they send you a refund, which ain't no refund. Give me my change, man. All y'all talking about, I can't wait for my no, you can't wait for your change.
Right.
Okay? Give me my change. Like when you was a kid and they sent you to the store
Right.
with a 20 for something that cost $8.
Yeah.
And you walk around with $12 in your pocket, your daddy is not getting a refund.
Right.
He's getting his change.
Right.
Okay? These are the people who are in control of your stuff.
Right.
If you don't get a will. So pick up with power of attorney.
So, like I said, power of attorney is only good for when you are living. That's just the way it is.
Yeah, that's crazy.
So, there's a lot of things you can do with the power of attorney. And so, typically, what a power of attorney does is you give somebody the authority to make decisions for you and on your behalf.
Okay.
So, when you are choosing this person, you need to be extremely careful. And you need to vet that person 100%, because what you don't want to happen is to assign someone that power and they go against everything that you wanted them to do.
Yep.
At that point, once the power of attorney kicks in and they're able to make those decisions, you really can't undo it because they're allowed to make these decisions.
You can't revoke a power of attorney?
It depends.
All right, well then let me ask this question and you give me your depends. How do I obtain a power of attorney? And then tell me why I can't revoke it.
Okay. So the best way to obtain a power of attorney, see a lawyer.
See a lawyer.
Right. That way we can figure out what exactly it is that you're trying to do, because there are different types of power of attorneys or sometimes other documents that we could make that could accomplish whatever it is you're trying to do.
Okay.
Okay. So depending on how your power of attorney is worded, it can kick in two instances. Usually the power of attorney is good as soon as it's signed.
Okay.
You can put a provision in there, however, that says this does not kick in unless, for some reason, I can't make my own decisions.
Oh, okay.
I'm no longer confident to make my own decisions, or I'm incapacitated, and now the document kicks in, and that person that you've chosen, which is called your agent, they can step in and make these decisions for you. They can take care of your finances. They can do everything that you've given them the power to do in that power of attorney.
Okay.
Okay? So when you asked if it can be changed, it depends. Because if your power of attorney does not kick in until you become incapacitated in some way, then you don't have the ability to change it at that point.
Gotcha.
Okay. Gotcha. That's a lot. And you know how step on Marcus J, live from the den, Legacy Internet Radio. So who needs a power of attorney?
Everybody.
Really?
So, and I'm going to say this in kind of a bugged out way, but you'll understand because you understand me. So, a generally healthy 43-year-old male who owns a home and a business, who is pretty much in good shape to handle his own affairs, needs a power of attorney?
Yep.
Okay. Now I'm intrigued. Why would why would someone who would appear, depending on who you ask, some folks think I'm crazy, but but someone that would appear to have their mental faculties, because you understand where I'm going, and obviously the way I'm asking the question, I'm asking it as a layperson, and you're giving me the above the glasses look. You know, this how she looking at me, y'all. This how she Facebook Live. This how she looking at me. So you're giving me that face because you can't wait to go pow. That's why. So go ahead and get your pow moment.
So you need it because, especially if you want it with the provision of if you become incapacitated or some way you're not able to make your own decisions, you never know when that's going to happen.
Okay.
You know, especially with foods we eat, lifestyles we live, you never know when you're just one slip away from stepping on that ice outside, falling, hitting your head, and then now you can't make your own decisions or you're incapacitated and somebody has to step in and handle your business for you.
Okay.
Okay? So it doesn't have to be your spouse. It could be anybody that you choose. That is your choice.
Okay.
But again, if you don't have these things in place, then what happens is sometimes the state has to come in and make these decisions.
Yo, I ain't rocking with the state. Need to
And
mind his
so,
business.
that's why I said it ties into the advanced health care or the living will. Because in your power of attorney, you can put directions on what to do as far as your health care is concerned.
Okay.
So both documents are really necessary. We're all one car accident away from being in the hospital, being incapacitated, and you can't make your own decisions.
Okay. Okay. All right. So, and it's a lot and whatnot. It's a lot. Ain't no hashtag on Marcus J. Live from the Den, Legacy Internet Radio. We're in the debut of our Legal Eagle segment with our sister attorney Tamika Robinson. We've talked about wills. We're in the midst of talking about powers of attorney. I'm still, I mean, obviously I don't have to be sold, don't matter, because I ain't no lawyer, ain't no judge, and I'm not a lawmaker. So it doesn't matter what I think about power of attorney. But I'm still, I guess I'm not really sold on why I need a power of attorney if I'm all right, because like the state, let's say about that car accident example.
Uh-huh.
I leave here tonight, the unthinkable happens, not with regards to my demise, but you know, I get hit and I'm broken up a little bit. And you know, my family, if they can't be reached for whatever reason, the state is who determines if they turn that machine off for me.
Could be. So let's even back it up a little bit further. Let's not even go as far as turning off the machine. Let's go as far as
Because
your
I'm bugging
treatment.
now, like for real.
So hypothetically speaking, we're not going to use you because I don't like to talk things into existence. So we're going to talk about Johnny.
So you're going to mess up Johnny, though, right?
Yeah.
You're going to mess up Johnny, though, right? Johnny has a family and a future. Oh, so because we don't know Johnny, we could just throw shade on. See,
Johnny.
see,
We
I
don't
see
know
how you
Johnny.
do, man. I see
But
how
we're
you
going to
do.
use Johnny. So Johnny is driving along, minding
Can we
his
say?
business.
Can we not say Johnny? Can we say Donald?
Okay.
Okay.
Donnie
Yeah.
is driving along, minding his business.
Why you
Donnie
laughing for? What'd I
gets
say?
into a really bad car accident. Right?
Okay.
Donnie is transported to the hospital. There's no information, and the doctors don't know whether Donnie wants to be resuscitated or how far they want him to go, of how far he wants him to go for life-saving measures, for treatment, for anything else like that, right?
Yep.
So in Virginia, specifically, if you are in the hospital and there is a medical situation and you have to be treated in order to avoid further harm, the hospital can petition a judicial officer for treatment.
Wow.
And that judicial officer looks over the paperwork. They speak with the doctor. They figure out what's going on, and then they can decide to issue an order to allow the hospital to treat you.
Okay.
That happens more often than you think. Not necessarily because somebody's been seriously injured, but maybe because somebody's in the hospital and the doctors think that that person doesn't have the capacity to make the decision to be treated. And if they're not treated, they're going to suffer serious injury.
Not sure that question is relevant, but I am curious. How long would that take? You know what I mean? Like, the doctor decides at 9 o'clock in the morning that I can't make my decision, and it's a serious situation where they feel like they need to do something for me. Like, how quick can something like that happen? Because when I think of courts and law and stuff,
Minutes.
I got a cousin that's been sitting in a jail cell for 2 years waiting for his trial date. So, I mean, you know what I'm saying?
Theoretically, minutes. Because here in Virginia, they could go to the magistrate.
Okay.
They would make a phone call and say, this is the hospital. I have a patient going on. I need here in Virginia, it's called a medical TDO.
Well,
right?
Explain to the folks what a magistrate is,
So-
as it relates to a judge or a lawyer or whatever.
So in Virginia, a magistrate is a judicial officer. Not a judge, not a law enforcement officer, but they are tasked and they are given they're giving authority by the law of Virginia to handle legal decisions.
Okay. So would it be like an arbitrator, similar to an arbitrator?
Similar, yes.
So
Very
that's
similar.
that's the kind of mindset that we're
Yes.
thinking with. Okay. I
Very
got you.
similar to an arbitrator. So, what would happen is the hospital would contact the magistrate's office, quick telephone call. This is so-and-so from St. Francis Hospital. We have a patient. They're this old. This is what's going on with them. We don't think they have the ability to consent to not being treated. And if we don't treat them, this is what's going to happen.
Okay.
And so then it's up to that magistrate to decide whether or not to issue this order for the hospital to treat you. More often than not, they're going to issue the order because they don't want anything bad to happen.
Right.
So now you've left it up to a completely perfect stranger. And it doesn't matter whether your family is in agreement or not.
Right.
It's solely up to the decision of that magistrate.
Gotcha.
That's for Virginia. Now, other states are different.
Yeah. Gotcha. Ain't no half step with Marcus J. live from Den Legacy Internet Radio. I haven't given out the phone number, y'all. 804-402-2893 is the number to dial. You want to rock with us, we'll roll with you. That's the number to dial if you have questions or comments about the legalese that we're speaking of. That includes you guys on Facebook Live. If you guys are watching and listening and you have questions about something that you see or hear, by all means, input your question, and I'll read them to our legal expert, our sister attorney, Tamika Robinson, our legal eagle. I just like saying that. That's how come I keep saying it. It just sounds cool to me. The nice alliteration. 804-402-2893. All right, so the last thing that we are going to talk about, and all three are on the table now, to ask questions and comment on if we choose to. But the last one is what?
Advanced healthcare directives. Most people also know them as living wills.
Okay.
So I'll introduce this with this case. How many people remember the Terri Schiavo case?
I definitely remember the Terri
Okay.
Schiavo case.
So Terri Schiavo case happened back in 1990.
Has it been that long?
It's been that long. That's when it started. It was back in 1990. So just a quick recap of the Terri Schiavo case. This is a case out of Florida.
I'm getting old,
where Miss Schiavo had a heart attack. And as a result of her heart attack, she had brain damage and she's in a coma.
Right.
So Miss Schiavo is married to Mr. Schiavo. And then there's her parents.
Yep.
Okay? So in 1998... her husband petitioned to have her feeding tube removed, saying that she wouldn't want to be in this environment. She wouldn't want machines keeping her alive. She can, remove her feeding tube and just let nature take its course.
Right.
So the parents opposed.
Yes.
They said their daughter wouldn't want this. She's a Roman Catholic. She would never do this. She would never go against the church. So now you have the husband versus the parents. There is no living will or advanced health care directive in place.
Okay.
So in April of 2001 is the first time her tube was removed. Remember, I told you in 98 they petitioned.
Wow. Okay.
So now you're talking about a 3-year fight
Right.
in the courts.
Right.
Then shortly after her tube was removed, they put it back in a couple days later.
Okay.
Fight continues. February 25th of 2005, it was removed again, 4 years later,
Okay.
right?
Yeah.
More fighting back and forth. Finally, in March 18th, to be exact, of 2005, the court finally said,
Enough.
enough.
Yeah.
Take it out, leave it out. We're upholding all the past orders that said you could take it out. And Ms. Schiavo died March 21st of 2005.
What was the date that they took it out again?
Finally, the final takeout
I'm trying to
date,
gather how long it took for her to pass. What was those?
March 18th of 2005 was the final takeout date, and
Okay.
she died on the 21st.
Okay, so a couple days later.
4 days, yeah.
Mm-hmm.
Okay.
So keep in mind, this is a 15-year fight. Over the 15 years, there were 14 appeals and other hearings in Florida courts, 5 federal cases. 4 times this case was denied to be heard by the Supreme Court of the United States as far as a right to die.
Right.
Had there been a health care directive in place, that would have squashed all of this. So for 15 years, Ms. Schiavo suffered with the squabble back and forth between her husband, who you would think would know what her wishes are,
Right.
and her parents,
Who you would think would
who
know
you
what
would
her
think
wishes
would
are.
know who her wishes are.
Right.
Yeah.
So now you're putting the burden on the court to decide, and you see the back and forth.
Right.
So advanced healthcare directives are not hard. None of these documents are hard to get. Okay, just talk to an attorney. Most of them you can get for relatively cheap. But I can just do it online. Yes, you can find the forms online maybe, you can fill them out online maybe, but you need to make sure that what you're doing is in accordance with the law.
Right.
That is where the attorney comes into play.
Gotcha.
So if you're going to do it, make sure that you do it right. They can be changed. Your advanced healthcare directive can be modified, but in there, you're pretty much going to tell people what you want to do if you are in a situation in the hospital and maybe you're hooked up to machines and there's no chance of recovery.
Right.
Something important happens, surgery, whatever, that's where your DNR comes into play that you asked about before. If you don't want them to take life resuscitating measures, you put that in there and it's fine.
Yeah, that's what I was asking you about before we went live, DR. Right.
So when you go to the hospital now, or when you get ready to have surgery or anything like that, the doctors will always ask you, do you have an advanced healthcare directive or a living will? They will ask you those questions, yes or no. Sometimes they'll give you DNR paperwork if you ask them for DNR paperwork, but do not resuscitate paperwork only kicks in if your heart stops
Okay.
and they have to resuscitate you. All the time in between there, as far as your treatment is concerned,
They have to take care of you.
they're going to have to take care of you, and it's going to be a battle between whomever to decide how you're going to be taken care of and what happens to you.
Right. And you know, I asked Devin Marcus J. Live from the Dan Legacy Internet Radio. You know, I love these kinds of segments because we can laugh, we can joke about things that may not be easy to talk about.
Right.
You know, because as I'm listening to you, like I feel my whole mood kind of change.
Right.
You know, when we.
It's like so many questions.
Yeah. I just like this last one. I literally feel my mood just like, you know, not in a bad way, but just, you know, I just feel the seriousness of it kind of come over me, you know, because it's something that I know. You know what I'm saying? Like I know I need to do this, and I haven't. You know what I'm saying? And I know I need to do this. And so I'm glad that we're talking about this, and I'm feeling encouraged by my own feeling of, you know, just like, wow.
Right.
You know what I mean? Like it's kind of heavy.
Right. I got a question from our big brother Hakeem. He said, "But how would the hospital know if we have a POA in Donald's case?"
If there is someone there with you, they're always going to try to find a way to contact the next of kin if you end up in a hospital. And so they'll ask that next of kin, do you know if there's a power of attorney? Do you know if there's a living will? Which is why it's important, if you have these documents, to communicate that to people so that they know where it is, who's supposed to be in charge, those types of things.
Okay. I got you. I mean, we had a lot of information in, and I'm definitely glad and happy that we did it. Any final words or anything that you want to add to kind of try to tie it all together before we move to a close?
Sure. Just generally speaking, I know this is a very, very heavy topic, very heavy.
But necessary.
But it's very necessary.
Right.
And one thing that I want people to understand and recognize is it doesn't matter your status. It doesn't matter if you're married or if you're not married, because there's a lot of misconceptions that go on between, well, I'm married or I'm not married, but so-and-so knows my wishes. Well, let me speak on the non-married part, especially in certain states. If you become ill, I'm just going to use an example, Marcus. If you become ill and you have a partner and you are not married, but your partner knows your wishes, your family doesn't have to abide by that. They don't even have to let you in the room.
Yeah,
because
we've seen
you are
that.
not a family member.
We've seen that on TV shows and stuff. Yeah,
That's real. That is real. So if you have something that you want to happen, or if you have somebody that you want to make these decisions, you need to put it on paper while you are able. You cannot call. I got a call the other day. Someone's mother was ill in the hospital. And they called me and said, can you come to the hospital and do a power of attorney?
you did.
No, I didn't. But that's not the time to ask a lawyer to come do a power of attorney. The chances of you getting somebody to come to the hospital that quick to do a power of attorney is slim to none. You're talking about somebody that's sick in the hospital. Are they medicated? There's so many factors that play into the fact that more likely than not, you can't do a power of attorney or anything at that point, because that person is not going to have capacity. They're not in their right mind to make these decisions.
Right.
So the time to do it is when you are just chilling.
Yeah.
When you're happy, when you're joyful, just ask your partner, ask whomever, what are your wishes? If something happens to you, what do you want? Let's write it down. Let's get it documented. That way you have everything in order. I tell people all the time, I laugh about it, but I tell them we're all one car accident away from having to use any of these things.
Right. No, that's the serious part. That's the real part, because, we can be, as I joked about it, but not really joke, but as kind of tongue in cheek, but on real talk. I mean, we can talk about how uncomfortable we are by these things, but it's uncomfortable getting a colonoscopy. I went ahead and did that. So sometimes you got to do uncomfortable stuff to make sure that you're okay, going forward.
Yep. Just make sure the person you choose to be your decision maker is willing and able to do so.
Okay.
You only really want one person. You don't want to say, well, I'll have two people and they have to make the decision together.
Because that complicates
that
stuff.
Just complicates it, and it's pointless at that point.
Right.
You're really just making a big circle.
Right.
Whoever you choose, make sure they are willing, make sure they are able, make sure they're not going to get in their feelings when the time comes, and they can follow your directions. So if you have somebody and you already have these documents and you're questioning that, you need to verify with them if they can do it.
Right.
Or change it and have somebody else that can do it be able to do the job.
Right. Hakeem said that's what he was saying. He thought they couldn't contact the next of kin in Donald's case. Maybe he misunderstood the scenario. So he's with us. Ain't no half step on Marcus J, live from the Den. Legacy Internet Radio. Outstanding segment. Great information. It's one of those deals where we could probably go and do a whole show on this kind of thing, but I think we got the basics out. And you're going to be doing something similar to this every single month?
Every month.
So,
In the meantime, if you have questions, you can email me, robinsonfirm1, that's the number 1, @gmail.com. or you can call me, 804-601-6615. I'll do my best to answer your questions, especially if it's a state in which I'm licensed. If not, I will try to at least get resources to you and maybe connect you with someone that can help you.
All right. Ain't no half step on Marcus J. Live from the Den, Legacy Internet Radio. We're going to take a break. This will be our final segment that we've just done. Is our final segment that we're doing tonight on Facebook Live. So if you're rocking with us on Facebook Live, I'm going to ask that you go to TuneIn, the TuneIn app on your phone, search Legacy Internet Radio and pick up the stream there. Or you can go directly to www.legacyinternetradio.com and press the Listen Now button and press play. You'll get us there. Those are the two ways that you'll be able to pick up the rest of the show, which you do not want to miss. Shout out to my cousin Tony, who's checking us out. Shout out to you, big cuz. Good to see you on there. Love you, brother. The rest of the show, you definitely want to get into this. We're going to have a Shampipple room with our brother, Mr. 3375. We're going to have that. And we're also going to have a discussion on Black Panther with our Legacy Internet Radio alumni, Mr. LP Steven Sykes. So in the Shampipple room, we're going to talk about Black Panther, and then we're going to talk about it some more with Mr. LP Steven Sykes. We're not going to be on Facebook Live going forward. We do ask that you go ahead and pick us up on TuneIn, search Legacy Internet Radio, or go directly to our website, www.legacyinternetradio.com. I want to have this opportunity to thank Tamika again, Attorney Tamika Robinson. You're going to be hearing more from her as a new member of the crew here on Ain't No Half Step on Marcus J. She'll be joining us monthly to talk about legal topics, our legalese from our legal. Ain't No Half Step on Marcus J, live from the Den. Legacy Internet Radio taking that break, y'all. Be back in a few. Stay with us.